Good day, ladies and gentlemen, our esteemed viewers, listeners, and subscribers to Accent Radio, and welcome to another interesting and exciting edition of Let's Talk with Asset Litigation. I remain your host, Barrister David Onu Njoko. And as usual here in Asset Litigation, what we do is basically sensitizing the public, bringing to the public the front burner issues, whether they are related to politics, entertainment, sport, as long as they have a little bit of coloration of legality or legal laws, then we'll toss us to discuss it here in Accent Radio. Now, what we do basically is to ensure that we sensitize the public and ensure on mass legal literacy. That is our core mandate here, mass legal literacy. We don't want the situation where our public is misinformed on the position of the law with respect to things that happen around them, maybe social issues or social events around them. And today's edition promises not to be any different. And today we'll be discussing the interference of the court in the right of labor unions to strike. The interference of the court in the right of labor unions to strike. If you recall, on the 29th of May 2023, during the presidential inauguration at Eagle Square, our President Bola Ahmed Tinubu, said there that subsidy was gone. That word alone, that phrase alone, subsidy is gone, raised a whole lot of dust, economic dust per se, as that's led to a very high rate or skyrocketed the rate of premium motor spirit known as PMS from 185 naira to about 520 naira and 600 naira respectively, which is currently the price. And it equally had a ripple effect on prices of goods and commodity transportation and even inflation in the country. Now, on the 2nd of June, just barely 4 days after that inauguration and inaugural speech, the Organized Nigeria Labour Congress and the Trade Union Congress gathered and then gave the federal government 5-day ultimatum to revert back to the old price, otherwise they face mass strike action nationwide. And that led the government to swing into action, and they went to court. That means the National Industrial Court, where the government now obtained an interim order stopping NLC or TUC to embark on that strike. That's nationwide strike which they have already threatened. And many persons ask the question, is it that the days of Oshomole, the good old days when LSC we can just wake up and they declare strike and the next day everybody complies to it? Is it that those days are gone? Or what is the problem actually? Is it that the rights of labor unions to strike has now been gagged, is now being frustrated by the courts? All these are the questions we are going to answer here today. And by the time we are done, I believe you will be in a better position to answer these questions yourself. Because here we raise the questions, we give the solution, and we allow you to arrive at the resolution, personal resolution on your own, without having to prompt you on what to say or what to stand on after the end of our program. Now, we have to understand that the right to strike is a fundamental human right. You know, under Section 40 of our laws, the law provides that everyone is entitled to peaceful assembly and association, including the association of any trade union of his choice. Now, these trade unions, the essence of the trade union is so as to protect the collective interest of workers within a workspace. One of the fallout or outcomes or the consequences of this very trade union gathering or meeting is so as to pressurize their employers to for better welfare packages and to ensure that there is a conducive working environment for their members. And when the employers fail to do this, they wield the big stick in the name of strike, so as to pressure their employers to ensure workers' welfare and better working conditions for their members. So we can say that right to strike is a fundamental human right coming from the right to association and right to be part of any trade union of one's choice. Now, from time immemorial, there have been issues of strike, right from the days of the artisans at the Royal Necropolis El Maderas in Egypt as far back as in the year 1152 BC. There has always been strike up to the present time in our current history. And even under the International Labour Organization protocol, it is equally enshrined there, which Nigeria is a signatory to it, that one of the consequential rights of workers is the right to strike. And those rights, such rights shouldn't be impeded. Now, but the question now is, in Nigeria as a case study, is it that we can just allow trade union to wake up any morning, and because they are not the policies of government is not sitting down well with them, they decide to embark on strike without any checks at all? We are a country of laws, and laws guide all our actions. So under our laws, what the law provides is that there are condition precedents that the Nigerian Labour Congress and Nigeria Trade Union and all its affiliates unions must or comply with before they can embark on a strike. Now, these conditions are basically 5, and I will take my time to explain them. Number 1 is that the trade union the trade union must have met with their employers for the purpose of trying to negotiate or trying to amicably settle such disputes. Number 2 is that where they try and they fail to amicably settle such disputes, they must have submitted themselves to a conciliator for the purpose of resolving that is dispute. If after 7 days of submitting themselves to a conciliator that didn't work, they have to revert to the Minister of Labour and Productivity, who then will constitute the Industrial Arbitration Panel for the purpose of trying to amicably settle the dispute amongst the workers and then their employers, here being Nigerian Labour Congress, Trade Union Congress and its affiliate bodies, and the federal government. And when that industrial arbitration panel has given its award, any aggrieved party that is not the arbitration award doesn't sit down with him or her can now go to the National Industrial Court for the purpose of ventilating his or her grievances. That is to say, if the industrial arbitration panel goes ahead to give an award that the Nigerian Labour Congress can go ahead with their strike, then the federal government has the right to now approach the National Industrial Court for the purpose of stopping the execution of such award. Or if the award says that the labor union doesn't have any right to go on strike, the labor union can now approach the court to demand that their right, which is the fundamental right of to strike, is being infringed upon, and that the National Industrial Court should give them the go-ahead order to embark on such strike. Except these condition precedents are met, then there will be no need to go on strike. Now, the second thing is that what makes a strike illegal, or what makes strikes illegal under our laws? Maybe you may be hearing this for the first time. What do you mean by illegal strike? Are there illegal strike? Are there illegal strike can be the issue? All strikes are legal as long as it's NLC or TUC that declares such strike. Our esteemed viewers, there are certain strikes which under our laws and several judicial decisions has held to be illegal. Now, one of the things that makes a strike or that makes strikes illegal is where the employees of such that wants to embark on such strike, they are under the essential duties category of workers. Now, these essential duty categories of workers include security personnel under the armed forces of Nigeria or the Nigerian police, oil and gas workers, those who work in the hospitals, tertiary institutions and institutions of basic learning, and transportation sector. Now you may ask yourself the question, if those in the security outfits, the oil and gas sector, the hospitality sector, like the hospitals and medical sector, we have the transportation sector workers, and then the education sector workers. If this category of workers are said to be under essential duties and as such prevented from going on strike, then which other body of workers is now mandated to go on strike? Because this seems to be the prominent of them all. And if it's only when this set of persons go on strike that the government will tend to listen to the yearnings of the ordinary masses of Nigeria. But that is not just all. the acts equally provide, that is the Trade Disputes Act and the Trade Union Act, equally provides that such strike, or the reason that must have necessitated the strike, must be that is on dispute of rights and not dispute of interest. There are two different things. That is to say, the labor union that wants to embark on strike, the reason for that strike must be a dispute of rights. The dispute of rights here means maybe under contract of employment or under a joint agreement by both parties. Any of the parties has failed to keep up to its own obligation in that agreement. That is a dispute of rights. Or under the contract of agreement, any of the parties has failed to keep to that agreement. Let's say the government has failed to pay the minimum wage of 30,000 naira as it is currently. Then that is a dispute of right that will warrant a labor union to embark on a strike. Now, when it is not a dispute of right but dispute of interest, by dispute of interest we mean it is not something that is directly connected to their rights as workers, but it has to do with social issues, issues of possibly fuel hike, issues of transportation hike, and all that. Now, when they want to embark on this very strike, this has strike bordering on dispute of interest and not dispute of rights, and as such the law does not approve labor unions going on strike on dispute of interest. Rather, it only approves labor union going on strike on dispute of right. I hope you got that right, so that nobody now comes tomorrow to blame the court when the court decides to win the big stick and then interfere in the rights of labor unions to go on strike. Also, we have to look at whether the labor union has kept to the obligations as stated under the Trade Union Act and under the Trade Disputes Act. We earlier cited 4 conditions under which a labor union can now go on strike. That is to say, they must have found amicable ways of settling the disputes by themselves and their employer. Secondly, that they have appointed a conciliator for the purpose of resolving the dispute, and that dispute broke down without a resolution. Number 3, that they must have submitted themselves to an industrial arbitration panel set up by the Minister of Labour and Productivity for the purpose of amicably settling the dispute, and an award has been issued. Then number 4, that the aggrieved party has now decided that is a party that is not at home, or that does not want to embrace the whatever decision that has been given by the arbitration panel, will now approach the National Industrial Court for the purpose of ventilating his or her anger. Now, if the labor union has failed to keep to any of these very 4 conditions precedent, then they are not entitled, or they are not mandated by law, or rather whatever any step they now take in going to embarking on the strike, that strike will not be declared null and void, or will be declared illegal by the courts. Now, having discussed this, we need equally to understand and know where is the thin line between the rights of labor unions as a fundamental human right to strike, and then the powers of the courts to interfere in this very right to strike. Now, remember that Section 40 of the Constitution, which provides for the right to strike, is not absolute right. It is a right that is equally going to be guided by other laws aside the Constitution. That is to say, where there is any other law that has some form of conditions that it has placed for the exercise of the right to strike, such other laws must be taken into consideration before the labor union can embark on any strike. And also, under the National Industrial Court Act, the Act has given the National Industrial Court the powers to interfere or interject in the right to strike by labor unions where that strike is going to cause untold hardship on Nigerians, either by way of is against public interest, whether it's against public security and public safety, or it's against, or it will cause an economic sabotage of the Nigerian economy, then the courts can interfere in that instance. And in this current situation, the current scenario we have in place, we have the the NLC, that is the Nigeria Labour Congress, and the TUC, the Trade Union Congress, wants to embark on strike based on or the reason that fuel subsidy was removed, and then there was hike in fuel price, and then which effect or consequences had to affect prices of food, prices of transportation, and etc. Now, that dispute itself is, number one, a dispute of interest and not a dispute of rights. And as such, the court, that's why the court gave its order stopping NLC and TUC to embark on that strike. Number two, the strike is going to affect the economy of Nigeria, as it has a way of crippling the economy. Our economy currently is in dire state, and as such, the court interpreted that action or the would-be action of NLC and TUC to be that may amount to economic sabotage, and as such had to step in to prevent them to embark on the strike. Number three, currently students are preparing for their WAEC examination. If TUC and NUC goes on strike, it will equally affect the National Teachers Association, and then it will equally affect the outcome or the conduct of the exercise of the WAEC examination. And as such, that will be against public policy for students to now meant to stay back at home rather than going to write their exams, because teachers will now go on strike. So it is for these reasons that is why the court had to step in, using their powers, enormous powers under the National Industrial Court Act, to wade in to prevent TUC and LLC from embarking on the proposed strike. Now, having established these grounds and these factors which will warrant labor unions to embark on strike, and the powers of the court which is inherent in them as provided under the different laws, whether be it the National Industrial Court Act or the Trade Union Act or the Trade Disputes Act, which empowers the court to interfere in the rights of trade unions or labor unions to embark on strike. We believe we have laid the proper foundation and we have cleared the air with respect to the powers of the court to interfere in the rights of labor unions to embark on strike. As usual, we will always want to hear your feedback, comments, and suggestions. So we'll encourage you to leave whatever comments and suggestions you have on the comment section of whatsoever streaming platform you're listening to us. And as usual, we will always give the prompt response that your comments and question suggestions deserve. If you want to read more on this topic, please feel free to go to our website www.lawasset.com. Click on the resource icon and you will see the article on this subject matter, so that you can read more and then you will be better abreast or in tune with this topic. Until we come again your way next week, as we say here in Law Asset Litigation, keep the hope alive and keep praying for a better Nigeria.